Hi, this is Anthony, parent of Iris Medic, and we restarted this podcast in June. And John and Keith have been really helping me, and I have been learning so much. And I have been blown away by some of the hidden things. You know, as a tax attorney, you need to know a lot of other things, like when you're subject to actual taxation. Now, one of the things that we're sort of taught and believe as people who are suffering under the U.S. tax code, we often believe, you know what you need? You need a second citizenship. You better get another passport. You better do that or else. And I'm actually going to take a contrarian view to that. I actually believe second citizenships are a lie. You really can't have two citizenships, and I believe the law has been perverted. And I believe that this is all our march to something that's a little scary to me, and it's the global citizen. As I see it, and a few others do, that what we're seeing with FATCA and the IRS and citizenship-based taxation is the precursor to a global system of taxation, and leading this fraud, and I think that's the word I would use, is the belief that you can be a citizen of two different countries. Joining me today is John Richardson, and John has posted a post of where this all came from. You know, it used to be a point in this country that if you voted in another country's elections, well, that would implicitly mean you're no longer a U.S. citizen. And the country was free to say, okay, you've relinquished your citizenship by an overt act demonstrating that you're no longer loyal to the United States. And that's the way it was. But then, well, the Supreme Court weighed in on a case in the 60s. And as I read it, and this is a post that John put up, and as I read it, this is the start of so much of the terror that goes around the world. John, can you tell us what is going on in the 1960s? And this is a weird name. Let me get your post up here. And this is a case I never heard of until John mentioned it, and it really is utterly essential. And the case is Afroyim versus Rusk. And this is John's post. He just put it up today. And you said you had some updates. So let me just refresh there to see, make sure I got the latest version. Oh yeah, you did. Okay, great. Afroyim was a case, 1967. And at first it looks like it's a good thing, but when you start to think about its implications, it gets a little nauseating, as I would say. So, John, can you tell me what this case is about and what it did?
Yeah, you're gonna have to bear with me a little bit, okay? Because at this moment, I think the great lawyer J.J. Robinette once said that a lawyer is a practical historian. So, in any case, I think that anybody who's listening to this probably is affected to some extent by this, and I think would probably agree with the general principle that the U.S. has, and I will add, has always weaponized U.S. citizenship. It's always been weaponized. Now, through the early part of the 20th century, and there's a fascinating book on this by Professor Amanda Frost called "You Are Not American," which probably be worth a separate video podcast. She details the attempts by the U.S. government to strip people of their citizenship through the years, and other ways that it was weaponized. For example, in Dred Scott, the decision holding that a black man would not be a U.S. citizen, this sort of stuff, right? I mean, the bottom line is that it was always weaponized, and it was weaponized as a way of, you will not be a citizen, we will take away your citizenship, which is not a comfortable thing at all, and frankly, downright frightening. Well, as always, there are people on the other side of the issue. And for a number of years, the question in the area of citizenship law was, how can Congress just take away people's citizenships, right? I mean, what's going on here? I mean, because I mean, in a democracy, right? People think of it as majority rule. I mean, is this supposed to mean that a majority of people in one country can look at a minority and say, buddy, you know what, we've just taken away your citizenship, right? And and that's largely a political question, as it is in some countries. But in the United States, as we know, or if you don't, you know now, that in the late 1800s, the 14th Amendment, which historically was for the purpose of giving freed Black citizenship, includes everyone born or naturalized in the United States is a U.S. citizen. Now, I want to make clear that's a constitutional provision. That's just not some bozo statute. Okay, constitutional provisions are things that prohibit governments from doing things generally, right? I mean, that's why you have it. That's why you have rights of free speech, equal protection, because governments are going to abuse them. And there's probably no government in the history of civilization that has abused citizenship more than the government of the United States. I mean, you'd be hard pressed to find any. Well, maybe the British.
Oh, yeah.
The War of 1812 was fought over the notion, okay, that, if you were born a British, you were forever British. But, citizenship has always been a problem. And for 99% of humanity, it's not a problem until, well, it is a problem. And once it becomes a problem, boy, there are no small problems in the area of citizenship. But in any case, so here we are. We have a constitutional provision that says, you're born in the United States, you're a U.S. citizen. All right. Now, what the decision in Afroyim says is that basically you're given the citizenship is something you're given by the Constitution by being born in the United States or naturalized. But let's take the naturalization out of the discussion for a minute, although it would apply. You're born in the United States. You have a right to U.S. citizenship. Now, what happened with Mr. Afroyim was that, and by the way, he was not somebody like Bittner, who obviously had the money to fight FBAR penalties at the Supreme Court of the United States. I mean, he's a person of modest means. And this was run through the courts through basically public interest litigation, et cetera, because of the principle involved. And in 1967, on May 29th, 1967, when I was a young boy, had no concept of any of this at all, the Supreme Court of the United States, per Justice Black, in a 5-4 decision, rules that the 14th Amendment guarantee of birth in the United States controls U.S. citizenship, meaning, no, governments can't come in and just take it away, de-citizenshipize you. All right, they can't do this. So there's two parts. The government can't take it away, but you can voluntarily relinquish it, right? It belongs to you. It's yours to relinquish if you want. So arguably, the decision stands for two principles. First, the government cannot take away your citizenship. Now, although the context of this was the prohibition on voting, the same principle would apply to all expatriating acts, including becoming a citizen of another country. Okay, including that, although I'm not sure it was obvious at the time. Now, let's pause for a minute and just imagine what that means. All right, when we look at citizenship, there were plenty of Americans who were born dual citizens because they were born in the United States and they had a claim to the citizenship of another country because they were born to perhaps an Italian or Irish parent or grandparent, right? So those people always were dual citizens. But what it opened the door on was that somebody born in the United States who is, why don't we call them citizenship paupers, who have only one citizenship, could then actually go out and naturalize as a citizen of another country and be dual citizens, all right? So the bottom line is that the Afroyim case, it seems to me, reinforced two basic points. The first is how easy it is to get U.S. citizenship. Right. And the second is that it's harder and harder to lose it. So easier to get and harder to lose. Right. Now, if you think about citizenship in the abstract, you'd think, wow, that's awesome. That's a good thing. But the thing is that, as we know, U.S. citizenship is special. U.S. citizens are special. Too much has been given the gift of U.S. citizenship, much is expected, specifically taxation. In fact, the United States is the only country in the world, where birth in the country will automatically give you citizenship, and that imposes worldwide taxation based on citizenship. So the bottom line is, and this is amazing, is that one of the primary effects of the Afroyim decision that never even mentioned taxation, nobody even had a clue what was going on, but because U.S. citizenship, the nature of it is that it is pure taxation-based citizenship, what it did was it set the stage to dramatically expand the U.S. tax base into other countries, facilitate things like FATCA, etc. So the question is, how do you look at this? I mean, if you look at it as a citizenship decision, pull up a little bit to the top of the post, Anthony. All right, the tweet there. Yeah, okay, click on, if you will, click on that. Click on the video. So you see, you look at that decision and you look at it as a young, great start to a new definition of citizenship, or you can look at it as exacerbating an old, obscene rule, right? Now, what's interesting is the people who have no awareness of what U.S. citizenship really is, which is taxation-based citizenship, would hail this decision as a vindication of constitutional rights, etc.
Yeah.
But those who understand what U.S. citizenship is presumably would see the danger. Now, at that time in the 70s or the 60s, nobody could see the danger. Now, let me just pause for a minute and talk about some of the things that happened in the tax area after 67 that have been a problem. Now, although I recognize that FBAR is not taxed, 1970, Mr. FBAR is born in October of 1970. Mr. FBAR is creating problems today, right?
Oh, yeah.
Okay. And then we move to, actually in the late 70s, we have the Carter administration getting rid of the foreign earned income exclusion temporarily. By the way, the Afroyim decision comes down in 67, 5 years after the Subpart F rules are enacted. So, I mean, nobody even understood what was going on there. Another, initiative from the, from the Kennedy administration. Then we move into the 80s, all right, the 86 Reagan tax reform, or, perhaps it was bipartisan, but that was where the PFIC thing was created. It also contains a provision specifying very specifically that if you have a CFC that doesn't pay 90% or more tax, it's Subpart F income. Then we move into the 90s. Okay, now the mid-90s, the Clinton administration began the creation of the exit tax. Because there were a few wealthy Americans who expatriated. So by God, let's punish them all. 1998 or in the 90s again, I don't remember the exact year. Clinton administration again created the foreign trust rules, creating a presumption that trusts were foreign. 1996, because corporation is not defined in the Internal Revenue Code, it leaves Treasury open to define what a corporation is, literally deemed many of small business corporations in other countries as per se corporations, setting the stage for 2017 to confiscate those assets. Then we have 2003, 2004, the FBAR rules were expanded, handing the administration over to the IRS. We have 2009, 2010, the Obama administration with its vicious, unprincipled, unprovoked assault on Americans abroad through, the OVDI programs and this type of stuff. We have 2010 FATCA. We have 2014 countries surrendering their sovereignty through the IGAs. And what is it that facilitates this? U.S. taxation-based citizenship. That's the beginning, the middle, and the end. And what was it that supercharged it? The 1967 decision of Afroyim, which essentially made it easier and dramatically expanded the base of dual citizens in other countries. So that's what's happening here. Now, let me just pause and we can chat a little bit about that before, where this might go. But it's an amazing history. And I think that all of these, advocates who, and frankly, I think all these people who are involved in this discussion, all right, particularly the younger people who have no consciousness of any of this history whatsoever, all right, I think would be well advised to understand this, okay, that decision that had nothing whatsoever to do with taxation really, I'm not going to say planted the seed, but certainly planted, turbocharged it, and definitely created the conditions that have existed today. So, was it a good idea to constitutionalize U.S. citizenship? I don't know that it was, but one other thing I want to add on this, just for anybody out there who's listening, this is a general problem. The constitutional guarantee of citizenship is for people born in the United States or naturalized. It does not apply to people born outside the United States, and they can be stripped of their citizenship, no problem.
Well, and that's sort of the issue that I was looking at this case that how do you say his name? Is a little weird one. The plaintiff here, Mr.
Afroyim, yeah.
He wasn't born in the U.S., was he?
He was naturalized.
He was born in Poland.
He was a naturalized U.S.
Okay,
citizen.
he was naturalized. Okay, so
Yeah.
okay. Now and this is what I was mentioning. Looking at this decision, and this is the birthplace of accidental Americans. This decision really is, because without this, the implicit acts of relinquishing one's citizenship would just be a given. Then the fact that, the person doesn't live here or have any ties and actually votes and is part of a totally different country where they have a citizenship, that would go away. But by creating this thing that, and really, and I think you said it really well, it's so easy to get and hard to lose, right? Well, what happens is it doesn't mean anything then, right? If it's easy to get and hard to lose, so hard you don't even want it, right? And that's the thing. These people don't even want it, and you can't lose it unless you go through what is now a very complicated and what can be a very complicated process to expatriate because of the tax implications.
Well, that's right. And let me just add this, Anthony, that the description I gave was citizenship from a nationality point of view. I mean, we can probably do a separate discussion on this, but on June 3rd, 2004, Congress recognizing how great U.S. citizenship is, and that the only thing that could be better than one U.S. citizenship would be having a second kind of U.S. citizenship. Therefore, on June 3rd, 2004, Congress gave all U.S. citizens a separate citizenship called tax citizenship. Okay, so I mean, really, U.S. citizenship, the only thing it's about is taxation at this point, all right? And, the combination of all of this has created essentially a fiscal prison. It's like the Hotel California. Well, you can check out, you want to go overseas for a year or two, but you can never leave.
Indeed. I mean, it is. Well, you can leave. It's just not easy. And for a whole bunch of people, it's really an inappropriate process. Someone who's had no connections to the U.S. And, to me, I'm just more of the opinion. I don't really believe in second citizenships all that much. I believe people should be able to go wherever any country's going to have them. But you really can be only loyal to one country. You really, yeah, sure, two countries may not be at war, but there will become a time. It's like being married to having several spouses.
Well, in the Muslim world, apparently, that's, at least in some parts of it, that's apparently okay. But Anthony, so, I mean, this is interesting because, we get into what, the nature of citizenship. You think it has something to do with loyalty. I actually don't think it does. I mean, the commercialization of it is, I think it's, largely a matter of convenience and tax documents. And I think it varies tremendously. I mean, if I were to say U.S. citizenship is about taxation, would you agree?
Yeah, and I am definitely speaking of an idealistic world.
Yeah, yeah.
Right, you're absolutely right because it has, in practicality, it has nothing to do with anything. There is
No. John said it. It's a matter of convenience.
yeah.
Yeah.
So hey, Keith. So what do you think about what's going on here?
No, I find it, John really laid out the evolution
Mhm.
of what has occurred since this particular ruling in 1967. So I find it fascinating. I really do. And it does come up today with the people with whom I speak, because a lot of them don't understand, what relinquishment means, what renunciation means, what the difference is between the two of them. And how does one go about relinquishing if they relinquished? How do they prove it? Especially if they did some type of act a number of years ago. And if they need to prove it, who do they go as a professional to make sure that it sticks? They come up on this. So it's a lot of, for me, it's the practicality on what does somebody do if they think they've relinquished their citizenship, their U.S. citizenship voluntarily. How do they prove it?
Well, so if you look at the national, okay. So let me first of all say this. All right, that the law, if you were to look at 349A of the Immigration Nationality Act, speaks only of relinquishment. It doesn't talk about
Renunciation.
Not one section for renunciation, other for relinquishment.
It
speaks only of relinquishment, and renunciation is one form of relinquishment. Okay, it's one form of relinquishment. It's not a different thing. It's one form of relinquishment. So from a legal status, it's all about relinquishment. Okay, of which renunciation is one example. Because I don't think this is all that well understood. There has developed a tendency when people talk about it to distinguish renunciation from relinquishment. So in that context, renunciation is where in present day time you would go into the consulate and do the oath of renunciation. Relinquishment is understood to be something you did outside the consulate that would be an expatriating act that you voluntarily did with the intention of relinquishing U.S. citizenship. Now, to give I think a fairly obvious and basic example would be, somebody who lives in Canada. I mention that only because it's where I live. I see a lot of this, right? The same thing applies, though. Substitute Canada for your country if you want. So somebody who does not have Canadian citizenship naturalizes as a Canadian citizen, right? It says, well, and I'm doing this naturalization voluntarily, obviously, and with the intention of relinquishing U.S. citizenship, right? And as long as they don't then hold themselves out as U.S. citizens, because remember, the State Department has an administrative presumption that all of these expatriating acts are in fact done with the intention of retaining U.S. citizenship. Therefore, the burden of proof is on the individual to show that they actually intended to relinquish U.S. citizenship. And I'm going to tell you, okay, that is getting harder and harder to get these effectively. It's getting harder.
Yeah. How do you do it? How do you do it, John? I mean, if the burden of proof is on the individual to show that they relinquished, what action do you take?
Well, you need to write this up in a certain way, et cetera, et cetera. I mean, it's not rocket science, but it does need to be done properly. Get professional help. All right.
Okay.
Absolutely get professional help. Anybody can renounce. That's not a problem. But on the outside, the backdated relinquishments, I do not think I've seen too many people who just don't get them. They just refuse them, and it can be just a word off here or there. That's all that's required. Now, the thing is, though, that you need to add to that when these relinquishing acts took place, because remember that we have tax citizenship now, too, right?
Yeah.
If the relinquishing act took place after June 3rd, 2004, you're going to need a CLN. You're actually going to have to get a CLN, Certificate of Loss of Nationality, to sever tax citizenship. So, you're going to have to go and interact with the consulate and have this, kind of discussion. So what you see, what's
John,
interesting, is you don't.
I just want to interrupt on that point, if you don't mind.
Yeah.
Because when I started getting into this and getting more clients who are trying to relinquish their citizenship, I always saw that 2004 date as like, okay, if it happened before here, it's this. And now, what I didn't realize, it was the act you were mentioning that did it. Could you just describe that act? What precisely? Because you said it created. You said it created a U.S. tax citizenship in 2000.
Yeah, yeah. Well, yeah, I'll try to describe it. I mean, so I think it was the American Jobs Creation Act was what it was called, but whatever it is, the title had nothing to do with this.
Of course, right.
Okay. But okay, to answer this completely, you're going to have to indulge me for a second so I can give you a bit of the background here.
All right, here we go. That's why we're here.
All right, so look, here's the problem. Under the nationality laws, like say 349A that we were discussing, you may have noticed or not that a certificate of loss of nationality is not a requirement to have relinquished U.S. citizenship for nationality purposes. Right. Okay?
Yeah.
So what was happening was that there were people who were just taking the position they had relinquished U.S. citizenship and therefore were no longer American citizens subject to the Internal Revenue Code. Well, I mean, for a country that sees its citizens nothing but taxpayers, right? This is not good.
Yeah.
So what they did was they amended the Internal Revenue Code to basically say that regardless of your citizenship for nationality purposes, the only way you're going to lose citizenship for tax purposes, in other words, cease being a U.S. citizen for tax purposes, is if you have a CLN and for the years 2003 to 2007 file an 8854. I mean, I can go into it in more detail,
okay,
right? The law changed again in 2008, but that's the basic principle. Now, probably should add this, though, that the 2004 law had a provision in it that specifically said from this date onward, meaning June 3rd, 2004, right? So from 2004 to 2008, it's pretty clear, right, that if you're dealing with this issue in that context, that it wouldn't have applied to you, right, if you'd relinquished citizenship for nationality purposes prior to June 3rd, 2004. They changed the law again on June 16, 2008, which is when they ushered in the exit tax rules. And it was pretty sloppy legislation, very sloppy. But it omitted the words from this date onward. So you get a lot of legal firms, accounting firms, to actually read the provision retroactively, right? So there are certain law firms out there that take the position that, say you relinquish U.S. citizenship in 1970 as a Vietnam refugee when you came to Canada, that all of a sudden effective June, this is their position seriously, okay, that effective June 16th, 2008, that if you didn't have a CLN, you were subject to 50 years of retroactive taxation and penalties. That's what the interpretation of the retroactive impact of it means, which, is completely idiotic, okay? It's completely idiotic.
Yeah, but I'm sure there's a lot of legal fees that generates.
Oh, it does generate, and it has generated a lot of legal fees. This is bad. I think it's bad stuff. There are no guarantees in this area, okay, because this stuff is still new. But my general advice to people would be, first of all, this is definitely not a do-it-yourself exercise, okay? There's too many moving parts. But my general advice would be, if you believe that you've got a relinquishing act prior to June 3rd, 2004, I would begin thinking about your problem from the point of view of having ceased to be a U.S., of never having been a U.S. tax citizen under the new rules.
Oh, right. Yeah. Right. Okay, I see your point. Right. How can you retroactively be made a tax citizen when you?
No problem. You call up any number of law firms; they'll tell you.
Yeah, I know. Right. Yeah.
Oh my God. Yeah. Oh, you lost citizenship in 1970.
And you
have a CLN? No, buddy. 50 years of retroactive taxation and penalties.
That's why you got to stay away from those law firms.
Well, I think you can really do have to stay away from them.
Be careful.
But how's anybody supposed to know, right?
Right. No, and that's what we're for.
Well, that's why we're doing the podcast.
That's why we're here. We're trying to spread this word. And yet, and these are just, for me, these are just fantastic podcasts. These aren't necessarily to get the greatest amount of views, but really for the hardcore to kind of get into the issues a lot deeper. And it takes a lot of questions, and sometimes we meander a little bit, but I always think the conversation is just so worthwhile as we talk about things that I'm just flabbergasted I didn't learn in law school. And I could be an attorney for 20 years and not know this.
That's why these podcasts are good reference material.
Right. And as a tax
well, that's
attorney,
why I don't consider myself to be a tax lawyer.
Right. And I don't know what I was
just sort of a general, general legal advisor, in these areas. I mean, there's so many moving parts.
Right. And that's that's exactly my point. I don't know how I'm a tax attorney. I don't know how you could be a tax attorney only when, well, I mean, for certain things, obviously, but on this stuff, because all these other issues come into play that are outside Title 26. I mean, it's endless.
Yeah, I would say that is correct, and it's very, very interesting because I sort of got, I don't know, I was interested. I got motivated, to help people in this area during the early OVDI years. Okay. And the reason I did was because I saw what many of these firms were doing, telling people, they were liable 50 years of retroactive, and et cetera. And they were putting them into the
I think that's how you and I became friends. That's right.
But what I saw very, very clearly was, at least at that time, right? And as time goes on, there are fewer people that can make these arguments, but at least at that time, what was discussed as a tax issue was actually a citizenship issue. Okay. And, the same way that if you look at the Afroyim decision, and by the way, there are other decisions, right? But Afroyim is the seminal decision here. Okay. As I look at that, I could see very, very clearly that this, that there were other dimensions to this that I thought were more important, from the get-go. Because the truth is this, that Americans abroad, because they're American citizens, 24/7, they have to protect themselves. Okay? I mean, they're under constant assault from the United States. It's 24/7. I mean, the very fact of citizenship taxation is a sanction on them, right, for leaving.
Oh, I mean, John. Well, if I ask my clients, like, okay, so, tell me the level of stress the U.S. tax code gives you, okay, and I'd get a number there, and then I would say, tell me the level of stress your own countries where you're living, what it gives you, and even in high tax jurisdictions, what I'm told is, yeah, but they don't hate you. These taxing jurisdictions, and I think Keith is one. He says in France, they actually don't hate you.
They actually help you. They really do.
Right. And in these other countries, they actually, and I see, I see it myself. Like, no, they're actually much easier to deal with. And so it doesn't have.
You can go in to see them. You can actually sit down with somebody, make an appointment.
And boy, I was just in the New Haven IRS field office yesterday, 140 Court Street. I showed up there and went through security with my client, and then they said, "Oh, the IRS is closed today." I said, "Really? We have an appointment at 11." And he says, "Well," and he goes, "Oh, are you going to the 5th floor?" I go, "Oh yeah." He goes, "Oh, that's open." I said, "Oh, okay." He goes, I said, well, "What's going on?" He said, "Oh, the field office that actually helps people is shut down because of staffing or whatever reason, so it's not even open now." Before, and now another thing is, before, years ago, say 2015, if you showed up at 10:30, you're too late to be seen that day. So it wasn't like it was great before, and now there's just, there's nobody there, and people are looking for their refunds, and so that's really something that we lose in all of this. We're like, well, these countries around the world, they tax higher and they do this and that. It's like, right, but they just tax and leave you alone. But, you know, the IRS wants to humiliate you and control you first, and make you go through all these hoops. And they may not get any money, but they got you to do things and they got to control you.
Well, Anthony, I think it's this, right? That if you look at, I think it's a trend that generally runs through U.S. law, is that everything is prohibited unless expressly allowed. Everybody is penalized unless you fit in with an exception. You know,
Right.
Everybody in the world is subject to U.S. taxation unless you're a non-resident alien, right? So it creates a climate, not whether you satisfy the conditions for the law to apply, but whether you satisfy the conditions to escape punitive application of it. And this is, by the way, why it is so, why, you know, as I've said before, I'm going to say it again, the reason for the difficulty in getting the law changed, I think, really is individual Americans more than anything else. And I think that the part, because they won't get behind any movement to really get anything changed. They want their problem solved, not the problem of citizenship taxation. But the motivating factor for that is that they need to escape whatever it is. They need to be part of the exception that gets them out of the problem. So I understand that. But I mean, until you know, people get themselves together and understand that they individually are not the center of the universe, that there's a bigger issue going on here, I don't think change is going to be possible. You know, and I don't think that it, you know, can really come from the political parties, etc. I mean, what was astounding to me was
No, it won't. It won't.
the
No one talks about it. No one does.
No.
it's America's deep, dirty secret.
No one even knows. They don't even know, right?
Even when told, though, they won't write about it. If you were to look at, you know, last week before the election, NPR, Time, to name a couple, and I think one or two others, ran articles on Americans abroad and voting. Not a single one of them mentioned the tax issue. I was interviewed by Canadian press the day after the election, and I made the point that the taxation was a reason why a lot of people did. That did not make it into the article. All right, interestingly. So, you know.
So, well, we have a lot of people inquiring about this, and I know there's a lot of green card holders who watch this channel. So, and there seems to be a lot of action. Green card holders. You just can't give up your green card in situations. You became a citizen, and so any special advice for green card holders?
Well, okay, green card. I find, I mean, doing a lot of, what I do is expatriation, obviously, okay, but I mean, I do a lot of green card holders and a lot of citizens. But what I find consistently is the green card stuff is almost always more complicated. Okay, almost always more complicated. Usually they have more money. All right, because a certain, you know, type of person.
Yeah, the person comes
you know,
here,
the
they
rules are very,
hustle,
very different.
and yeah.
The green card holders have opportunities for expatriation that citizens don't because of the dual residency rules and the tax treaties. You know, so I mean, all of this stuff is very, very interesting. Yeah, they're both you know, they're both governed by the same set of rules, 877A. Well, as long as the green card holder is a long-term resident. But you know, the stuff really plays out very, very differently. And one of the common differences, although this isn't written into the statute, I mean, I don't know if Americans abroad realize that the 877A rules operate so that if you have a U.S.-based pension, I'll give you an example. Say you're I mean, I've worked, for example, with a lot of Canadian citizen professors who taught for many years in the U.S. and moved back to Canada. And they have a pension fund, just making this up, say the University of California, and they're over the $2 million. You know, they're able to keep the pension, right? I mean, they just have, you know, they're going to be taxed on the distributions. But the same person who taught at the University of Toronto, because it's not a U.S. pension, would literally have a large part of that pension confiscated for expatriate, you know, as part of the exit tax.
Oh wow!
I mean, it's shocking in its depravity, right? But you know, you've got these, you know, these Americans running around the world ignoring this. No, you know, it's the problem. You're exaggerating. Wrong, and wrong. I'm telling you exactly the way it is. But they don't care.
Well, it's not a problem for them, right? It's an opportunity. So,
But the green card stuff, there's more of them getting rid of them because I think the word is out that you don't want to come to the U.S. with a green card, and certainly in the tech community, they know that if they stay 8 years, they're stuck, so they're going to get out.
yeah, and that's really the trigger. 8 years if you have a green card. That's when things go, and that's what I'm noticing too.
But you've got the benefits. There are certain ways to use the tax treaties that are available to green card holders that are not available to citizens because we talked about the saving clause, I think, fairly recently.
Right. Yep.
Anyway, it really is a fascinating area, and as a kid I played chess, and I actually see green card expatriations as an endless sort of chess game of trying to reorganize things so people can get out without being covered expatriates.
And just a covered expatriate means that you're likely subject to the exit tax, whether you paid or not.
Well, it means trouble. Okay, it means a lot of trouble for most green card holders for a very simple reason. And that is that it's one thing to not be subject to an exit tax because you don't have capital gains built in. But deferred compensation plans and specified tax deferred accounts are outside that group. And there's always problems with those. Okay. So, the best thing would be my advice to anybody on the planet would be if you want to come to the United States, don't get a green card.
Yeah.
Do it. I mean, you'll regret it. It's going to be the dumbest thing you ever did when you find out what it really means.
Unless you spend the rest of your life in the United States.
Right.
That's the only reason. Yeah.
Right.
Otherwise, forget it.
Is that even a reason to do so? I don't know. I mean, I understand that at least one very well-known NBA basketball player, his name I won't mention.
Yeah.
Played for a team and I think won a few championships. Never got a green card. Okay. He was always there on some other kind of visa and returned to his country of origin after retiring, probably with tens of millions of dollars.
He was smart. Somebody advised him well.
Yeah, of course somebody advised him well. And this is the problem with anything to do with the U.S. I mean, you have to go through life with a lawyer or accountant and tell them. I don't know about you, but I'm going to be honest. I hate lawyers and accountants. I can't stand having I mean, they cost money. You never know if what they're saying is can be trusted.
We don't have a great reputation, that's for sure. No, I mean it's everything. If you're trying to design sort of a terrible system, it's the people are ignorant and scared, and there's people who exploit that in all industries, and they lobby for the more complicated things anyway, as we've discussed before. John, I think we might want to because I noticed the green card expatriation, these issues are picking up, and it might be a great idea if we revisit that. I know one of my older videos on green cards is one of my best viewed ones. I think a little update wouldn't be a bad.
Yeah, we did one on that a few years ago. I remember on that. Yeah. It's a gigantic problem. It really is a big problem. I mean, this stuff. I mean, the problem is that the U.S. has become a fiscal prison. You can't really get out of it in any rational way. And I don't know if this was intended or not, but I mean, it's got 6 or 7 different tax systems going on, and it's largely status-based taxation, not what are you doing or where do you live, but tell me who you are and I'll tell you which tax regime. I mean, it's craziness. People need to renounce. All roads lead to renunciation.
Thank you, John. Keith, do you have any final questions or comments?
No, I learned quite a bit on this call, and I hope other people who are a lay person like I am have as well. I think the one key thing that comes out of this is that if you are planning on, renouncing or relinquishing your citizenship, that you really do need to work with a professional. Make sure that the I's are dotted and the T's are crossed. Obviously, there might be some exceptions to that rule, but generally speaking, it's best to get the guidance of a professional.
Well, you know what? I'm gonna put this out there to our audience. John and I were talking about this idea prior to our podcast today, but we're really thinking it may be an A to Z guide for expatriation, something we could do. and at least to give people, if it's something they can't do themselves, they could at least know to say, hey, to give them an idea what their professional should be doing.
Yeah, they can
Absolutely.
be a better educated consumer,
Yeah.
better educated consumer.
Yeah.
But it's the general, as I perceive the general discussion out there. It's all it is filling out a form renouncing. No.
Right. Oh, no. Depending. I mean, there are people who renounce and that's it. They just move forward. But
yeah, and not to say that I'm not claiming any consequences other than it not being done right, and who knows. That's there's not a lot of covered expatriation audits.
Well, there are right now, but look, here's the thing. Okay,
things change, right? You never
cannot predict. We cannot predict the future.
Right.
I say repeatedly that my feeling on this is, my honest opinion is, for people who can get out of this, according to the law, I really think they should. Because they can put this chapter of their lives behind them, and they don't have to think about this anymore.
And John, so it's like this. So what more do you need to see? What more do you need to see to say this is nothing? Nothing has been going the right way. It's all going one way. So everything that's been going on, it's really something, if you can get out, to get out.
People believe what they want to believe, okay? And I understand that. And I think that there is a group of people out there who, I think their problems are fairly marginal, right? Usually because they're not in the U.S. tax system.
Yeah.
But the ones who are in the U.S. tax system, I mean, these are the ones who are forced to renounce. I mean, what's interesting about the whole thing is that the people who are punished most are the people who try the hardest to comply.
Always.
Yeah. It's amazing.
That's just, I think, an objective fact. And these are the people who, really, I think, are highly incentivized to renounce. The other thing that we might talk about at some point is, the U.S. has essentially created a caste system of citizenship, okay, where, the people who are dual citizens from birth have a higher, better standard of U.S. citizenship than, somebody like maybe you, Anthony. I don't know. I think, you're a U.S. citizen only, right?
Yes.
I mean, unfortunately, you don't have opportunities that other people do for that reason.
No, that's not true.
Opportunities given by Italy or Ireland.
Oh, no, you got it all wrong. You got it wrong. John, if I was wealthy, there's a ton of tax shelters available. If I was really wealthy, there's tons of tax shelters away from me. And as we've discussed before,
yeah, but
the U.S. is the top tax shelter.
Life with a lawyer, accountant in tow. Okay.
Well, several. And good ones. Yeah.
Like a bus load of them. Okay. I mean, Anthony drives down the road.
All right. Yeah, all right.
Anthony's driving down the road. Right? Behind Anthony is a busload of lawyers and accountants to keep him,
Well, I mean, some I like, I like you. Oh man, this is just something else here. I mean,
it's incredible stuff. It is incredible.
You laid it out. I mean, you laid it out in a way I've never ever seen it laid out, and just giving as it's just showing the history of what it really is, and this little decision that no one ever mentions has significant consequences. I do want to just mention something. I mentioned accidental Americans. I don't want to necessarily lump those into people, as you mentioned before, people in the tax system. An accidental American in France, their problems are FATCA, right? Or that's going to that's what it's going to be.
Their bank account issues.
Their bank account issues, yeah.
That's usually their issues. It's not the issue that I better enter the system so I leave it. That's not something I don't
think they're at all concerned about that. I mean, the people who are not in the U.S. tax system are not concerned with the tax system.
Right.
Yeah.
And we're not telling you that you should change your belief.
They're just, they're concerned, and understandably so. I mean, everybody experiences this stuff differently. But the problem in getting change is that until people come together and realize that the problem is citizenship taxation and that it just manifests itself in different ways, you have different groups of Americans actually working against each other. Why would the U.S. make any change at all if Americans abroad can't even agree on what the problem is?
Right.
Yeah.
You know, and
Very
then,
true.
then they get sucked into, all the go vote, 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 vote.
Right. Vote for whom?
It's
For people.
completely beyond
Yeah.
my comprehension.
It is. It's bizarre.
Anybody would vote, 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 when it's very, very clear that none of these candidates are interested in their issue. I mean, I don't understand it.
Absolutely right. Yeah. Yeah. I think we have some that might be a little bit interested, but
Right.
it's not anyone's top priority. That's for sure. Well, there we go here. Oh man, this is just amazing. So let's so next week what are we gonna be talking about?
Well, I don't know. You can talk
Well,
about anything you want.
all right. Well, I know we wanted. Well, I know we wanted to do subpart F, but we can maybe talk about. And I don't think I have time to. I don't think we have time to put the. Or unless you want to do a green card update next week.
Well, we can
That
do
could be. There's so many.
All right, we'll see what we'll see what people vote for. How about that?
The thing
We'll leave
about
it up to our
subpart
viewers.
F
Yeah.
is that it's, the audience for this is limited to begin.
Yeah.
Subpart F is,
Green card update might be a good one.
Whoa! It sounds like you're doubting my ability to make subpart R to make subpart F interesting.
No, okay, we'll do it next week. No, here's the thing. I have to put together a presentation to do it. That's the problem.
Oh, all right. Well, then you know what? I'll let you decide, right? If you're,
Yeah,
I don't want
really
to dump the
problematic.
workload on you, right? And say, hey,
I got to
yes.
figure out how to make this so
Well,
simple that anybody.
How about that in a couple of weeks? Should we
But
do
here,
a green?
I'll give you the clue. All you need to understand subpart F is this. Why don't we just send this teaser out?
Okay.
All subpart F is when income earned by a separate corporation that's a separate legal entity is taxed directly to you, the business owner or shareholder, even though you did not get even 1 cent of it. So my question for listeners is, how would you like to have an extra, say, $100,000 appear on your tax return to pay tax to the United States when you never received even a cent of it? Would you like that, Anthony?
That is subpart F, and yeah, no.
Would you like that, Keith?
Not at all. Maybe that's why the initial F for subpart F is appropriate.
Ooh, he's correct. Yep, my sources say yes. Checks out, Keith. Yep, absolutely.
On that note, so the great, I think I may have mentioned this before, but the great investor, pioneer of foreign investing, Sir John Templeton. All right. He creates these things. In 1962, the Kennedy administration creates the subpart F rules, which, by the way, was an attempt to override the tax treaties. Okay. The tax treaty said that one country can't tax another country's corporations. So this was an attempt to override it by indirectly the tax by taxing the shareholder. But here's the bottom line. One of the greatest human beings ever walked the face of the earth, Sir John Templeton, 1962, the subpart F rules have been enacted. 1964, Sir John Templeton, Rhodes Scholar, investor extraordinary, renounced U.S. citizenship. So, Anthony, there might have been a correlation there. I mean, do you think there might have been a correlation?
It seems suspicious. Let's just put that down as let's check on that, right? That requires follow-up, I say. Yes. All right. Well, thank you so much, gentlemen. Another great podcast. Really, really a pleasure to be a part of this. I really thank you guys for your efforts. And I think we're really, spreading the word. And, we don't necessarily need to like things because we don't, but at least we need to define what it is.
Yeah.
That's what we're trying to do. So everyone, thanks again. And be sure to subscribe because we will be having some really, really fantastic updates for you coming. Thanks again.